Live at 5 this evening, we're joined by David Harrison and Andrew Scarborough, the attorneys for Coley McCraney, who's accused of murdering Tracy Hallett and J.B. Beasley. I want to thank both of you for your time today and for being with us here. David, let's, I guess, start with you tonight. Kind of update us on what's the latest with this trial right now, or the preliminary hearings.
Well, I think that obviously an indictment was returned. We have a arraignment set in August. And at that point in time, we'll have 30 days after that to file all of our motions before the court on issues to suppress and those kind of things, arguments that we plan to make.
Andrew, talk with us about this arraignment. Tell folks at home what happens during that part of the process.
The arraignment's pretty simple. There's no witnesses presented. All it is the formal reading of the charges. So in this instance, the judge will say, Coley Lois McCraney, you are charged with, and we'll name out the different charges. At that point in time, the defendant will make his plea. Obviously, ours will be not guilty.
Gotcha. Okay. So before we get to that point, though, the prosecution is making a move trying to block the media and the public from covering preliminary hearings through this process. Have either of you ever worked a trial or a case under circumstances like that before?
I have not.
Where that was approved?
I have not.
No, you know, I have. Again, I've been doing this job for 29 years. I've probably handled 3, maybe 4,000 criminal cases. I don't ever recall one being filed, much less filed by the prosecution. Usually it's the defense who doesn't want, who wants the gag order. In this case, it's the opposite of that. Now, so to answer your question, no, Ben, I've never seen it before.
No. Let me ask you this too, because everyone has an opinion about this, and of course the media, you know, obviously speaking. But what is your opinion of the preliminary hearings and why they need to be kept open?
Obviously, I think the first most obvious thing is the protection of justice. I mean, that's what the Constitution talks about. By allowing the media to come in, we protect the sanctity of justice. We protect the openness of the justice system, that it is administered fairly. I think that's the most obvious.
What about you, Dave?
Well, you know, I think this. I think that if you look at the big scheme of things, the state of Alabama has the burden of proof here. The state of Alabama, in this case, called a national press conference. Said, we have our man, DNA doesn't lie. Then the results of the DNA test were published, I guess, maybe 2 days before the preliminary hearing, and then right before a grand jury, obviously all the evidence was disseminated. Evidence that I have never seen before. Evidence that Mr. Scarborough hasn't seen before. Evidence that the prosecution had not given us, which they weren't obligated to at that point in time. That is officially giving it to us. Now, we had a preliminary hearing, obviously. So I think that what we need to do is transparency. A lot of people really think that it's about, you know, this personality or that one. It's really not. I think that the U.S. Constitution and the 10 Amendments were signed in 1791, and the First Amendment is freedom of speech, which encompasses the freedom of press. We need a transparency with government. If all of a sudden the people in Dale County or Houston County or wherever see that a judge or a government has sealed the documents being filed in such a case, I think it reaps of a problem. I think that we need transparency. This is a case where transparency needs to prevail over everything else, because there are a lot of innuendo, there's a lot of opinion out there, and if you shut down one side of it, then we're going to have a bigger problem.
All right, so the prosecution would argue that they can't get an unbiased jury pool if these hearings stay open up until the trial. Do you think you can find anybody in Dale County who doesn't know about this?
I don't, but there again, the impartial jury does not mean that they have no knowledge of the case. It's whether they can set any prior knowledge that they have to the side and be impartial. That's what is required. And so, as Mr. Harrison was saying, I think to shut down the public and the media's access now would be of more harm than to allow the public and the media to continue to have access.
I want to say this in relation to that, Ben. It doesn't matter whether they know anything about it. The issue is whether or not the judge, when he gives the jury charges, which he will at the end of the evidence, whether they can follow the law. I have cases all the time where a jury venire member says, well, I know something about this case. Well, the question becomes, can you follow the law? Can you follow the law as the judge instructs you? So to answer your question, absolutely, we can find people who will follow the law, and that's all we're asking for.
And knowledge is not a big deal. Just
No.
can you do your job
That's correct.
as a juror. We need to take a break on the television side. We're going to get back to this interview on DothanFirst.com where you can see the rest of it, and that's live right now.